Welcome to The Law Matters. Of course it does. My name is Debbie Moraes, your host and moderator. As we tell you, this long-running television program has continued to provide legal information, relevant examples, and practical assistance to help you with the law because the law matters. A better understanding of the law puts you in a better position to decide how to protect yourself, your family, and at times your business. We present various topics, and as we do, you may decide that you can handle some issues yourself. We try to equip you with information and resources to help that. If you do decide to seek outside counsel, our goal, of course, is to help you to be better prepared to achieve the best possible results while saving time and money. And once again, we'd like to welcome and thank Attorney David Bizarre from the Bizarre and Associates law firm in East Providence, who continues to provide us information and anecdotes, some interesting stories as we tackle various topics. And today, false accusations, arrests, false convictions, justice denied. Last segment, we talked about medical malpractice, what the standards of care were, how acknowledging that mistakes can happen, errors and omissions, sometimes with tragic consequences. In this case, it's not doctors and the medical industry, but rather police or others and the justice system. So what happens if you're falsely accused and convicted or imprisoned? What should you do along that process? What should you say? What should you not say? Should you get a lawyer involved? When do you need to get a lawyer involved? Maybe you should never answer a single question, even though you know that you were innocent, you have proof of it. What should you do? And then if you're cleared, exonerated, what happens to the person who had been your accuser, whether it was an associate of yours or the police? Do they have immunity? What can you do? What recourse do you have? So we're going to review a couple of examples, but let's go through this from the start, David. So what should you do, for example, if a police officer falsely accuses you of doing something, of a crime, and then by contrast, what about if somebody else just accuses you? So is there a difference in how?
Well, their issue about people who are innocent being accused of having done something they didn't do, and then being wrongfully convicted of something they didn't do, has long been an issue in the jurisprudence system, in our justice system, that we've always tried to guard against. And there's a saying in the law that it's better that, I forget, but I'll make up a number, 9 people who are guilty of a crime go free than 1 innocent person be convicted of something they didn't do. And so the system's designed so that we hope that that doesn't happen, but of course it does. And there are many instances of people who are convicted of crimes that they didn't do, and we have that Innocence Project that is often going back and looking at older cases when maybe we didn't have the techniques with DNA that we have now to try to prove somebody was wrongfully convicted and things of that nature. But there's a lot of that going on. So where do you want to start?
Let's, I'm going to refer to a case about Father Macrae in New Hampshire, but if a police officer accuses you of a crime, you're innocent in this case, say you are. What should you do? Should you start to answer questions? Should you not say anything? What should you do in those cases, just at the accusation level?
I think you're always best off having an attorney. And I know what they'll say. Well, you want an attorney, obviously you're guilty, otherwise you wouldn't need an attorney.
Correct, they do say that.
Right, that's what they'll say. And their job is to try to find out what happened and investigate a crime and get to the bottom of it. And if they have evidence that's pointing at you and they want you to confess to it, and so it brings back to mind a lot of different situations. Because if you remember, there was the case up in Wisconsin where a nephew, I think it was, and the uncle were charged with murdering somebody, and there was a lot of the investigation that was being reported in that series, and the nephew had some real difficult issues, mental issues, and mental capacity issues, and so they really were almost able to get him to say anything that they wanted him to say. And so my point is, you should always have a lawyer at the start whether you're guilty of what they're trying to investigate you of or innocent of what it is. And I'll give an example. You like anecdotes. I represented someone many, many years ago who was being charged with rape, and he didn't do it. And there was a lot of evidence that he didn't do it. And in this particular case, although he was being investigated for it, it was going to a grand jury. So what I did is I wrote a letter to the Attorney General who was in charge of the grand jury, and I laid out the case as to why my client wasn't guilty of what they said he was doing. And I listed out all of the witnesses who I asked him to call to that grand jury to testify, because they all had different pieces of evidence as to what happened and what didn't happen. And as a result of that, the Attorney General in charge of the grand jury actually did what I asked him to do, and the grand jury did not return a bill, an indictment against my client. No true bill, they call it. And so he wasn't charged.
So David, is that a typical course of action on an attorney's part if he's called to represent someone? Is that a typical thing that you might do or that a lawyer might do?
I think given that situation where there was evidence that could be used and should be used, and a good attorney general who was willing to look at all aspects of a case, then that was what generally should happen and you would do.
It certainly makes sense. But nobody would want to bring a case when you know that you can't win it. It makes you look foolish. It wastes the court's time, your time, everyone's time, and that certainly makes sense. So that sounds like a good thing to do. So when you first worked with this client who was innocent, did you immediately start to collect witnesses, evidence, and start building a case and all the rest of that? Did it take you a week, a month, a year before you got to the AG to do this? Well,
we had some time. And in order for me to properly represent him, I asked him the facts of the case first. And he told me what had happened. And then he told me all the people who were present and witnesses and so forth. So what I then did was I asked if they would be willing to come in and talk to me, and almost every instance they did. So I took a statement from them and went through it, and then I compared what each person was saying against what the other people were saying for consistency or inconsistencies. I was convinced then that the proper route here was to show that he didn't do what he was charged with doing, and presenting it to the Attorney General in the form of a letter, because that way it was in writing with everything that I thought he needed, with all the information, it was a he in this case, that he needed to be able to present it to the grand jury properly. So he had the statements from the alleged victim and friends of the alleged victim, and he had that information, which is why there was a case in the first place. But he also had what would have been the defense at trial. And so he was able to present all of that to the grand jury to decide whether or not there was enough evidence or lack of evidence to proceed with an indictment.
I guess it makes sense to say that if there is a trial, your defendant, your client, only has to prove that there is a reasonable doubt rather than whatever. But if that person knows that he has those list of witnesses that he's going to fork over to you, wouldn't that give him a very good reason to say, why would I need a lawyer? All I have to do is call Mary, John, Joe, and I have the restaurant receipt that proves that I was there at 9 a.m. and couldn't have done whatever. What you would follow that someone would logically say, I've got the evidence. What do I need a lawyer for?
Well,
what do you say to that?
That's one small piece of what the evidence may be, which may or may not in and of itself be enough. And so, like I said, I listened to every witness, took notes, and looked for every inconsistency, because I knew what the Attorney General would do, which was, if there were inconsistencies, poke holes in them and use that against you. So, yes, it's possible that you have an airtight alibi and don't need anyone to help you with that. And if that's the case, then so be it. But it's not often airtight as you think it is.
Good point. So let me ask also, would this make a difference? You were talking about a sexual
that was a charge of rape. And by the way, I just want to go back on one thing you said. My client wouldn't have to prove anything, reasonable doubt. It's actually the state's obligation to prove it beyond reasonable doubt.
Beyond reasonable doubt. Yes. So in this situation, you're talking about something that's a crime versus a civil situation. Does it matter whether it's a civil or criminal case? Do they still need to enlist an attorney for the reasons that you just cited?
So these are very
Yes.
different things.
Yes.
A criminal case brought by the state where your freedom and liberty may be in jeopardy
Yes.
is beyond reasonable doubt, as we talked about.
Yes.
And definitely, I think when that is at risk, you want to have an attorney represent you in those things. In a civil case, again, it's a different standard and different things, and it's usually a monetary risk. And so, can you represent yourself? I think is what you were asking. You can always represent yourself, but no, you shouldn't, in my opinion.
Good to know. So you brought up an example of yours with a rape case. The example that I wanted to talk about, we talked about briefly, was a Father Macrae who in New Hampshire had been falsely accused, yes, arrested, yes, convicted, yes, imprisoned for, I think they said 33 to 67 years. The detective, I believe his name was McLaughlin, had already been on someone's hit list, as a Laurie's list, for having been proven in unrelated cases to not be a very reliable detective and had had falsified documents. So some questionable issues there. As it's played out over 20 some odd years, that Father Macrae had been accused of in a sexual rape case.
Yep. Or sexual assault.
Sexual assault. We know now that it has been overturned, that detective had falsified the documents. His motive, I don't know, I didn't delve that deeply in it. But here's an example where someone wanted to make a case, and for whatever reason, I don't know his motive, but he falsified records. When something like that, a bad actor, never mind a mistake, but a bad actor is involved and it's the police, what recourse do you have? What should Father Macrae do other than hope Innocent Project picks it up before 27 years passes? What do you do?
Well, here's a couple of things that brings to mind. First of all, what probably happened with the police officer was that they had some evidence. Someone said that this is what happened, and they were pushing on that and didn't look at the bigger picture, but had sort of blinders on, I would say, and was focused in on this, and this is what it is. And again, there are oftentimes, and if you go back a ways, especially if a child accused an adult of sexual assault or rape of some type.
I think that was the issue, and they are very hot on that issue.
There was always, we have to believe the child, and again, an example I had was sort of a case that it came out of a divorce, and the child was accusing the dad of inappropriate sexual touching and so forth. And he said, this is not true. And it was really quite apparent to me that the mother was using it in this case as a leverage in the divorce. And so the investigation's being done. And I was really trying to push back on the police and whoever was looking into it at the particular time to find out, was it coming from the mother and putting seeds into the child's head, or was it the child really saying this? And they did a very good job in that investigation as well, where they were really able to separate out that it wasn't what the child was saying, it was being planted in there, and it was the child repeating things the mother was saying, and they were able to figure that out. That wasn't always the case. That case goes back 30 years. It wasn't always the case back then. It was always, well, the child said it, then it must have been what the child said. And that's what sort of happened, I believe, with this priest or father in New Hampshire.
Yes.
So the question you asked was, what's the recourse that he would have as having been in prison? And it's very difficult, impossible to sue really anyone in the judicial process, the system. There's judicial immunity. Right. There's prosecutorial immunity. So there's little recourse civilly that you would have in that.
Civilly, okay.
But in Rhode Island, if you remember this wrongful conviction, there was, I think he was a Warwick police officer, I'm not 100%
Yes.
sure of that, Jeffrey Hornoff?
Hornoff.
Right?
Right,
I think,
that's right.
I think he was accused of killing Victoria Cushman or something like that. Eventually, he maintained his innocence throughout the whole thing, but eventually somebody else came and admitted that it was him who did it, and he got out. And so he did sue, and he did get a recovery. But what the for one thing he got was he was a police officer, so he got a pension and a back due disability pension and back due money from that against the city of Warwick, I think it was.
Yes.
But the legislature in Rhode Island passed a statute, if my memory serves correct, so I could be corrected on this, but I think I'm right, that if you are wrongfully convicted and your conviction's overturned, that you could get $50,000 a year for every year you served in prison.
I read something about that too on the Rhode Island Innocence Project or something, and tied into that. So mistakes were made. When we talked about med malpractice, mistakes can be made. In this case, even if you're saying that there's immunity for a district attorney, an assistant, or an officer, what about in this case where this Detective McLaughlin had falsified documents, number one, set up a sting where he sent a letter and had it forged? So that's not errors, omission, honest mistake. Isn't there, that's misconduct, isn't that something else?
Yeah, so I don't know the law in New Hampshire, which is where this happened.
It's a state issue, okay.
Right, but if there is no immunity for intentional acts, and if you can prove that the investigation and the act was being done with malice and intent, and knowledge that what you were doing was to convict somebody who was innocent, there probably is liability for that person, but they're acting outside of the normal scope of their employment, so to speak. You're not expected as a police officer to use your position to intentionally inflict a conviction on somebody who's otherwise innocent. There might be some liability on the part of that officer for acting outside the scope of his employment in that sense.
I mean, it certainly makes sense that he could have been, just admonished, maybe retrained, maybe be fired, maybe lose his pension. And then, was it personal injury that someone might go back and sue an accuser if it weren't a police officer?
Well,
slander, libel, defamation?
If it weren't a police officer, I mean, there's cases for false imprisonment.
Yes.
There's possible slander or defamation types of cases, but that would be more in line with someone who's accused by a shop owner of shoplifting, so to speak, and they hold you and sort of falsely imprison you. Those are the types of charges you might want to civilly bring against that store for that.
In general, David, do courts hold police officers accountable for how they make an arrest, how they question the accused at the office? Do courts monitor that? And because a lot of times we hear about these terrible stories that police officers do terrible things. Not all of them do, certainly, but sometimes they don't go by the book and cost. What's the story about that, David?
Well, let's just use some examples that we already know of.
Yeah.
Can you be held liable as a police officer for doing things that are beyond the scope of how you're supposed to do them? Criminal acts even, and we know you can because we know what happened to the officer in the George Floyd case, for example.
Good example.
And what I believe, and again, I'm not 100% up to date on it, but I think the other officers too, and the particular officer who was convicted also had federal civil rights violations brought against them.
Good.
Right?
Good point. And in this situation with Father Macrae, now that he's out, there's no getting back those 27 years. Would you see as a lawyer that he would have a reason to pursue a suit against this particular detective where you know it wasn't just, oops, he made a mistake, or oops, there wasn't DNA, touch DNA as there is now?
Right. Again, I think you would have to look at more of the facts than I know, and federal law may provide some assistance to him.
Versus state?
Yeah, but, and again, the state of New Hampshire, whatever their laws. Again, as I said before, in Rhode Island, we know he would be able to try to get $50,000 a year for each of those 27 years that he was in prison.
It certainly seems that, there's some compensation of some sort that the family is due, but
Right.
however that plays out. Is it difficult to win such a case as, I don't know, your defamation, it's slander, it's libel, it's character assassination? He will never be a priest again. I'm sure not that he wants to be, who knows? And I'm sure Mr. Hornoff wasn't interested in going back and serving on the police force, but their lives are seriously affected, irreversibly affected.
Yeah, you're never going to be able to be made whole with money as a result of having spent for this fellow 27 years in prison, or 6 years in prison, or whatever it was that Mr. Hornoff had already served. I don't remember the years. But whatever it is, I think the state of Rhode Island's on the right track with being able to say, here's a fund of money that we can give you to compensate you, because bringing those lawsuits can be time-consuming. They can be difficult, and many times you probably may or may not be successful. And even if you're successful, are you ever going to collect anything back?
As a deterrent, or is it a deterrent, if you are representing that man who was accused of rape, and say it wasn't a child, it was just another person, is it effective? Is it ever considered to be strategic to, what do I want to say, volley that charge, or let that person who is falsely accusing someone that they could be suffering some consequences for their bad actions when you know that it's absolutely not true? We have hard proof, evidence, witness, whatever it is, and we're going to go after you. You might want to rethink this. Is that a valid strategy? Is that a thing that matters?
Yes. And I've actually have another case I can share, again, many years ago. So I had a client who had a no-contact order because he was being charged with domestic violence, domestic simple assault. And he came to me, he was being arrested for violating the no-contact order. And he said, I didn't. I was not doing anything. I was staying away. I was following the rules. She called me. I said, I can't talk to you, and I hung up on her. And the police said, nope, she says he called her. And they showed that they had some evidence that they said that showed that there was a conversation and he called her. I said, no, he didn't. I said, we will get the phone records and show you where the call was originated from. And he said to me, I don't believe your client, I believe her, and I'm going to go forward with this. I said, well, would you please go back to her and tell her that you're going to charge her with filing a false report if we get those records and they show that that's not true. And he did. And I can't recall if she backed down or whatever. I don't think she did, actually. And I think we did get the records. And I did show that she was the one who initiated the call, and that it was a very short call because my client hung up on her. And he did charge her with filing a false report. And
did that play out as you would expect that it should or would?
It didn't quite, because it took a while to get the records, because we had to subpoena them, and he wanted to go forward, and there was some difficult issues as a result of that. But he was somewhat apologetic to my client for trying to pursue that violation against him, but he did stick to his word about charging her.
So that can be an effective defense, especially if you know for certain sure that it was false. What about what's called a false arrest? And that's when someone's restrained or, please help. someone wasn't supposed to
Someone's
be arrested.
liberty is restrained so that they don't have freedom of movement.
Yes. So that's often interchanged or confused with what false imprisonment is, but they segue, they tie together.
Yeah.
Explain how that happens, and again, does that tie into an officer just making a mistake versus an officer has it in for someone, and how you prove that?
Yeah, and two very different things. If you're charged with something, false arrest, as you want to call it, that you didn't do, and it plays out that you didn't do it, and the charges are dismissed, it's almost like, sort of, in some ways, no harm, no foul. There's nothing really to go after for that, as long as they were just pursuing where the evidence was taking them, and that's what it seemed to be, but then it turns out it was different. As you talked about false imprisonment, and I'm usually not dealing with those situations with a police officer, but somebody else who has authority to keep you from moving, and that usually is a shop owner, where you're accused of shoplifting, and they hold you until the police come, and they've held you for a long period of time. It's very different. That's false imprisonment, and that can lead to a civil charge against somebody who does not have immunity who does that.
Often there's, I guess police get away with what's considered to be good faith. We just acted on what we saw, what the preponderance of evidence or whatever was going on. They have to make a decision.
Whatever the evidence might show.
Whatever it shows, at least at that moment. So is good faith granted to someone who is accusing you of some, I don't know whether it's really a felony or whatever, a crime, but if someone is pursuing, I don't know how to actually, I want to frame this, but help me with this.
Okay, so with the police, it's usually probable cause. That's what they want. Reasonable suspicion, probable cause, some reason to follow up on something, to get a warrant or some other investigative tactic to figure out what happened. With a civil case, it's not usually that type of situation, but rather is there any, as you said, preponderance or any evidence that what the person is saying you did. And again, there are usually different standards in different types of situations. But for a police officer to pursue the evidence and have either reasonable suspicion, probable cause to be able to do that, they're allowed to do that. And you see this oftentimes in they want to detain you and question you and do all of that and pat you down. Do they have reasonable suspicion that you have a weapon and that gives them cause to pat you down? They stop your vehicle and they look in the vehicle and there's something in plain sight so that they can go in and look at that. These are the types of things that are the evidentiary requirements, or not even evidentiary, but the rules for them on search and seizure to be able to pursue the evidence.
And they're doing these things on good faith. If an average person accuses you falsely, are they ever saying that what they're doing is on good faith? They're clearly in bad faith and worthy of having some consequences for, hopefully not just having cognitive dissonance, bad judgment, or deciding they didn't like what the person did after they did it or whatever.
Yeah.
No good faith there.
No, and so there is possibility of civil suits being brought against somebody who does do that. But it's within the eye of the beholder, so to speak, in some ways.
Sounds right. So we hope that this has been helpful to you in considering what false accusations and arrests are. We hope that it never happens to you, of course. We thank you for tuning into The Law Matters as we tell you it matters to you. Thank you for tuning in.